Thank you, sir. May it please the court, Steele Williams for the appellants, Sun Life Funding LLC and Michael Adverbot. The first issue to address this court is that a title owner of real property at the time of filing of a foreclosure is an indispensable party. In this case, Concordia Ventures was the title owner of the property when the foreclosure was filed. The plaintiff owner of the loan in years later dropped Concordia as a party. Thereafter, Concordia filed a motion to intervene, asserting that it still had a property interest. The title owner of the property at the time, Equity Trust, also filed a motion to intervene, asserting that it had a title interest in the property that was going to be affected by the foreclosure. The plaintiff, substitute plaintiff at that time, fought those interventions and then filed for summary judgment and motion for receivership. The reasoning put forth in the case law, the English case and in the Tahara case, is that once the lis pendens is filed, that locks in what the status of the property is and who owns it, what the encumbrances are. And the Tahara case is very clear that after that lis pendens is filed, the title owner of the property and no one else even can affect the status or that property.
If we agree with you on that point, we don't need to reach the other two issues, do we?
That would be correct, Your Honor. Under the case law that, and there's a 1888 case that the English court cited that said that if you do not have the indispensable party title owner of the property as a part of the case, then the foreclosure judgment is void and any sale thereafter is void.
Does that rule still apply if Concordia, after the lawsuit is filed, sells its interest?
It does, Your Honor, under the reasoning of what the lis pendens is to establish at the outset of the case, that Concordia cannot affect the foreclosing party's interest by transfer of its title or granting of interest to the property. None of that has any consequence as a matter of real property law in Florida, because the lis pendens establishes that break point in time that nobody can affect the title to the property without dealing with what's going on in the case itself.
So I continue my foreclosure action against a party that has no interest in property. Is that what you're telling me?
Well, if from a logistics standpoint, if the title owner has transferred the property and they don't have an interest in the property anymore, from a notice standpoint of the record of the real property record of the title to the property, the public is on notice that this case, that pertains to this lis pendens, affects the title to the property going forward. Now, if you drop the party that was the title owner of the property at the time the lis pendens was filed, that reasoning changes, because now the title record of the property shows that the title owner has transferred and been dropped as a party to the case. That will create problems with a view of the real property record of the title to the property. Did I answer your question?
Go ahead, I will mull it through.
Right.
Okay. Yeah.
Not saying you didn't, just kind of
Okay.
following.
I'll try to circle back. Okay. The other issue in the case that I'd like to address to the court is, and I call it the 1115 procedural rule requirement. I used to call it the 1115 procedural rule requirement, that if you're a foreclosing party, you have to comply with this new procedural rule. Now it's been 10 years, so it's no longer new. But that rule requires that you provide verification under oath that you can prove that you're the owner of this property or this mortgage instrument that you're foreclosing on. And that was a result of all the problems that occurred during the Great Recession with parties and entities filing suits on loans that maybe they didn't necessarily own or didn't know how they established ownership. In this case, in 2015, when the verified under oath foreclosure complaint was filed, 1115 was attempted to be satisfied by the filing of an affidavit of incomplete assignment, where the servicer, JP Morgan, and that affidavit is at 71 through 85 in the record, where the servicer of the loan says, yeah, we're missing assignments and there may be this gap in assignments. Well, in fact, there was an 8-year gap in assignments. That's a problem. So from the outset of this case, the foreclosing party never satisfied the procedural rule to verify to connect the dots. And that pertains to a situation where the note, the commercial instrument, has been lost. So they can connect the dots after it leaves JP Morgan and the like, but they couldn't connect the dots from the prior 8 years to the original lender, New World Mortgage. That was a problem in the case. Now, motions to dismiss were filed as to that issue. The court denied those motions, affirmative defenses as to the standing and the propriety of being able to establish standing at the time of the filing of the case have been asserted by all defendants in the case, including my appellant clients. But nonetheless, that non-final order denying the motions to dismiss because there was a failure to comply with 1115 of the Florida procedural rules has never had appellate review or review by this court. That is another reason to find that this case should be dismissed for a faulty filing, failure to comply with the basic rules of Florida Rules of Civil Procedure. If you can establish compliance with, the verification requirement that here I'm connecting all the dots of the assignments of mortgage, but hey, I'm going to say I've got an 8-year span where I don't really connect the dots and I'll just file an affidavit saying I can't connect the dots. Well, that's not complying. And then you don't even try to comply with an amended complaint later on or the like. By the time you get to a disposition of the case and a summary judgment, you're still traveling on a faulty complaint. And again, parties, defendants like my clients are unable to seek appellate review of that noncompliance of that procedural rule until a final disposition of the case and summary on the summary judgment that we're here before this court. There should be a burden. Procedural rules should matter. If the legislature has determined that we want to stop all the nonsense of people foreclosing on loans and then establishing the basis to do so after the fact, we're not going to do that anymore. The legislature, or the procedural rule enacted, I think that came out of the Florida Supreme Court, said we're not going to do that anymore. You have to, at the outset of the case, you have to verify under oath and establish how you establish the assignments of mortgage and connect the dots of your ownership for standing. That didn't happen in this case. Now, my last point, and I apologize for the hands.
That's okay.
Summary judgment is not appropriate when there's a conflict in the record. In this case, the successor plaintiff, I think it was the 5th or the 6th, maybe the 7th, came onto the scene in 2022 and filed its motion for substitution of party and filed a motion for summary judgment, a motion for appointment of a receiver. In the motion for summary judgment, the last page, there's this affidavit of transfer assuring the gap from the initial lender, New Century Mortgage, to JP Morgan Chase, NA. One, JP Morgan Chase in the original filing is identified only as the servicer, not the owner, but nonetheless. Okay, so this new owner of the interest of the loan asserts we have cured the gap problem. There was a quick response by Concordia that was then joined by my clients, Michael Averbach and the appellants in this case. Wait a second. New Century Mortgage back in 2006 signed an assignment of mortgage the day after closing, which is of record. New World Mortgage transferred the mortgage to New Century Mortgage the day after closing, which typically happened, so that they could replenish their funding line and lend the money to someone else. So that's direct evidence that when the new lender comes onto the scene the new owner of the lending obligation comes onto the scene in 2022, the appellee in this case, and they say, we've cured the gap. By now we've got an affidavit of transfer from New World Mortgage to JP Morgan Chase. Well, wait a second. New World Mortgage didn't have the ability in 2022 or 3 days after closing in 2006 because they had already transferred the obligation by an assignment of mortgage to New Century Mortgage, and that assignment of mortgage was of record. Further, there's additional conflicts as to the standing issue. There were interrogatory answers by other party owners, prior substitute plaintiffs in the case, saying, well, during that 8-year period of time, WAMU was the owner. During that period of time, the FDIC took over the obligation, the OTC took it over, and then it ultimately ended up in the FDIC's hands. Well, wait a second. There's that directly conflicts with this argument that the new owner of the loan is asserting that, hey, we can cure the gap by this assignment of mortgage or affidavit of transfer almost 18 years after the fact. And what's noteworthy, I think, and was not addressed at any level, and there's a judicial notice in the record where my clients put forth the corporate records of New World Mortgage. New World Mortgage has been a defunct entity since 2010. So how in the world is a defunct entity in 2010 signing an affidavit of transfer 12 years later, which directly conflicts with what they did in 2006, a day or two after closing, when they transferred the mortgage to New Century Mortgage? Doesn't make sense. But I still don't understand how that a defunct entity of 12 years from California can all of a sudden assign an affidavit of transfer that has more authority and more legitimacy than the affidavit or assignment of mortgage that they signed 2 or 3 days after closing. Nonetheless, so at the end of the day, the trial court decided the standing issue on a summary judgment basis. We come to this court on a de novo review. The summary judgment in this case should absolutely be reversed based on the conflict of evidence in the case. One key aspect as to this summary judgment issue is none of these conflicts of the evidence are addressed by the answer brief, unexplainably. And for these reasons, first, the fact that you dismissed the title owner of the property, the foreclosure judgment's void, this case should be dismissed. 2, the failure to comply with 1115 Florida Rules of Civil Procedure requiring verification of a complaint establishing your standing, your documented standing at the time of the outset of the filing never occurred, and it didn't occur through an amended pleading whatsoever. So the complaint that the parties are still traveling on is faulty, warranting dismissal. And third, the trial court should be reversed because of conflict in the direct evidence, multiple conflicts in the direct evidence of summary judgment testimony, a summary judgment record. And if I have any time, I'll reserve.
That's time.
Thank you.
Mr. Ware.
Good morning, Your Honor. May it please the court, Attorney Bryce Williams here on behalf of Appellee ARCPE1 LLC. I represent the prevailing party in the mortgage foreclosure action, and we ask the court to affirm the trial court's ruling. First issue that I would like to discuss is the Tahara case and the fact that it's distinguishable from the case at hand. Here, Appellant Sun Life Funding and Michael Averbach contend with Concordia as trustee of CVLR1 Trust, the fee simple owner at the time the list pendants was filed in this case, remained an indispensable party after conveying its interest to Equity Trust Company. They rely on the Tahara case to make that contention. This court.
You didn't address in your answer, Bree. So I'm glad you're addressing it now, because that's what I was gonna ask you, how you respond to it.
Right, and the distinguishing factor in my opinion, Judge, is that the Tahar case involved a constructive trust where JSCO was the plaintiff beneficiary of that court-imposed faction, that constructive trust. And even at the time in which that he deeded the property to Tahara, his beneficial interest remained by virtue of his lis pendants. In our final judgment, the beneficiaries and the settlers of CVLR1 Trust were still included in the final judgment. So their beneficial interest, similar to the reasoning of Tahara, that JSCO's beneficial interest by virtue of his constructive trust needed to remain in the final judgment. He was indispensable. That beneficial interest was indispensable. Here, the beneficiaries and the settlers of the CVLR1 Trust remained in the judgment. The only party who did not remain in the judgment was Concordia as trustee. And we would contend that in the Whitburn LLC versus Wells Fargo case, in this court held in 2015, that a post-list pendants transferee lacks standing to intervene in the case. So Equity Trust Company could no longer intervene in the case after they were transferred the property, and Concordia, who is the trustee of the CVLR1 Trust, no longer had the property in that trust for the benefit of the beneficiaries. The fund was no longer funded as soon as he divested his interest to Equity Trust Company. So our contention is that JSCO's beneficial interest by virtue of his constructive trust was the indispensable portion that Tahara was the reasoning in the Tahara case. And the reason it shouldn't extend here is because the beneficiaries and the settlers of the CVLR1 Trust, who were the beneficiaries at the time the lis pendants was filed, remained in the judgment. Therefore, the judgment should not be rendered void. So that's the distinguishing factor as far as Tahara goes. As far as counsel's second and third argument regarding ARCPE's standing and record conflicting evidence regarding standing, our argument here is that the appellees in this matter, Sun Life Funding, who their interest in the property is that of a junior mortgage, essentially, and Michael Averbach, who has a possessory interest in the property. There is no fee simple ownership between the appellants and the appellees, no contractual privity between the appellees and the appellants. They are strangers to the note mortgage. They cannot look to enforce the terms of the note mortgage. As far as standing goes, it is well settled that even strangers to the note and mortgage can contest and challenge standing in mortgage foreclosure actions. But the basis for that is that there's a due process constitutionally protected right for fee simple property owners to not have a third party come in and take their property. Here, none of that exists. Sun Life Funding is not a fee simple owner and not in privity with ARCPE, and Michael Averbach is not in privity with ARCPE and not a fee simple owner. So at the end of the day, they don't have standing to challenge ARCPE standing. So, as far as going on to, I know, Judge, you mentioned if you would agree on the first Tahara argument, that you wouldn't have to address argument 2 and argument 3. But I think it is important to note that essentially Sun Life Funding and Michael Averbach are acting as straw man appellants for Concordia Ventures and Equity Trust Company, who were transferring the property back and forth to one another during the pendency of the action. So I'm not sure where their interests align, if they're intertwined one way or the other. But as far as a matter of law, Sun Life Funding and Michael Averbach do not have standing to challenge the chain of assignments, the loss note affidavit, or any of those items. And that would need to be another defendant, Victor Barbish, who was the borrower in the case, or if Concordia did not divest their interest as trustee, then they would have the ability to contest that at the time. But the beneficiaries and the settlers of the CBLR1 trust were named in the judgment. And I think as a last note, I would like to point out that Concordia Ventures and Sun Life Funding shared affirmative defenses and shared an answer in this case. And the affirmative defenses were summarily rejected by the trial court. So even in the instance where Concordia was left out of the judgment itself as trustee, their arguments that they made on behalf of their beneficiaries and settlers who were in the judgment were addressed by the court. So for those reasons, we would ask the court to affirm the final judgment here because Tahara doesn't extend, because the beneficiaries and settlers remained in the judgment after Concordia as trustee divested, and Sun Life Funding and Michael Averbach do not have standing to raise the arguments alleged in argument 2 and argument 3. And with that, I would like to reserve.
Thank you, Mr. Williams.
Thank you.
How much time do I have?
Yeah.
Just briefly, this argument that my clients or parties that remain as parties to the foreclosure were still settlers of the CBR1 trust or beneficiaries, one that's not in the record, it's not in the briefs. I would just say that that's not a proper argument.
So you're trying to respond to his,
Yeah, I didn't see the fact that,
are you trying to respond to his argument distinguishing Tahara? Is that what you're doing right now?
well, I think the argument is that the remaining parties at the
No, I
trust.
understood what his argument was, but I want to hear your response because you didn't have a chance to respond in your reply brief because it wasn't in his answer brief. So could you please respond?
I'm not aware of Michael Averbach and Sun Life. I think Sun Life Funding had an option. It wasn't a settlor or beneficiary of the trust. It was an encumbrance on the property. It wasn't part of the trust by which Concordia was off of. But I'm not here to assess that issue. The Tahara case goes back to Judge Rose's comment is, what does it matter? The list pendants, and I'll try to make a better argument or explanation. List pendants establishes in time a specific set of rights and circumstances as to the property as of the filing. No party, the owner or other party, can affect the title to that property thereafter by a transfer or a granting of an interest. That's a bedrock principle of the law. This issue that, well, if you drop, what does it matter if you drop the owner of the party, the owner of the property after the list pendants? The problem with that is confusion would then be created in the title of the property because that dropping of the party would be reflected. So then, and let me explain. So does that mean if you drop the title owner of the property, then the due process rights of that title owner, even though they don't allegedly own the property anymore, aren't affected? So does that mean that the new owner's rights are affected or not? The bedrock principle that I identified to this court in initial oral argument was, in the English case, they cite to an 1888 case that the title owner of the property is an indispensable party at the time of filing of the foreclosure. That's the only and one only indispensable party. As to this distinguishing of the Tahara case, I don't think we have that on the Concordia, the title owner, or Sun Life Funding, which had an encumbrance on the property, or Michael Averbach, which had contracts.
You're saying that the judgment is void because Concordia was dropped, right?
Yeah, right. Yes, ma'am.
Okay, and what his argument was in response is, well, Concordia was just a trustee. And that's, the trustee was dropped, but the beneficiaries of the trust still remain. their interest is still represented. I think that was his argument.
And I think the counter to that is, one, I don't know that the beneficiaries are a part of the record. Two, I don't think the record identifies who the beneficiaries are. I don't think that issue was adjudicated at the trial level. I don't think it's within any of the briefs.
And that would not undermine your argument about the record of the title being affected, because the record of the title would show the trustee as the owner, not the beneficiaries of the
Right.
trust.
Yeah, yes, Your Honor.
So you could still have that same problem.
Yes, that would be correct. The title record would still be problematic if the title owner of the property were dropped
Whether they
out.
were the trustee or otherwise, the title owner goes away. And the fact that there were beneficiaries who may or may not still be involved in the case wouldn't be reflected in that record title.
There's no way it would be reflected. I mean, there's a maybe
Possible, but not
But-
necessarily.
possible, but unlikely if you're operating in the trust
On the
form
nature
of
of
real
trust.
property ownership.
Right.
So it's unlikely to even know who all the beneficiaries or who the settlers were to the trust, and that wasn't part of any record. Do you have any further questions? For the reasons enunciated in my initial argument, I think the case for dropping of the only indispensable party in the foreclosure makes the foreclosure judgment void. The failure to follow the procedural rules required to foreclose warrants dismissal of the case. And the summary judgment standard certainly was not met at the trial level. Thank you.
Thank you both very much. Exaltation of Larkson.